you. You may be seated. Robert Hriniak versus Fred Malden et al. And Bruno Appliance and Furniture Inc. versus Robert Hriniak. Saret E. Batner, Brandon Kane, and Moya J. Graham for the appellant. Javad Heydary, Jeffrey D. Landman, David K. Alderson, Michelle Jackson, and Jonathan A. Odumeru for the appellants in the second action. And I think I've got that right. Thank you. Mahalia Wilson and Christopher P. Thompson for the intervener, Attorney General of Canada. Paul R. Sweeney and David Stearns for the intervener, Canadian Bar Association. David W. Scott, Patricia D.S. Jackson, and Crawford Smith for the intervener, the Advocate Society. Alan Rubin and Ronald P. Bohm for the intervener, Ontario Trial Lawyers Association. Ms. Batner? Mr. Heydary.
Good morning, Chief Justice and Justices. Hearing your questions of my colleague, my friend, Ms. Batner, I was reassured of a crucial factor that I think is key in this case, and that's that culture shift. I think Justice Abella used the word, this romantic notion of a trial. What the amended rules were meant to do is to shift our culture. I think that's the term the AG's office uses. I believe Justice Cromwell focused on the practicality of the case. What is the context? What was the outcome? Process is not our obsession here. We're in the justice business. So with that introduction, I would like to proceed this morning, subject to your questions, with setting out some background, crucial background facts, because context is everything. I do have sympathy for this court, appellate court, highest appellate court in the land, to have to deal with facts, to have to revisit matters that go back years. But we have no choice, because to give meaning to the revisions that were made to the rule, we must consider context. And context has no meaning if we don't consider the facts of each case. To begin with, I would ask two questions, the who and the what. Who is the person who brings us here? We have to keep sight of that. Who is Mr. Hriniak? When we look at Justice Grace's finding, Justice Grace went through 4 days of hearing, 28 volumes of evidence. Mr. Hriniak was supposed to put his best foot forward. You lead by Trump. That's, even in the old system, that was our rule. Nothing changed. This is what Justice Grace had to say. Mr. Hriniak was a master of illusion. At least for today, his dodging and weaving stops here. That was said in 2010. And here we are 3 years later. Also, let us not forget one thing. The Court of Appeal, regardless of its decision on Bruno, he came to the conclusion, and he agreed with the motions just, Mr. Hriniak was involved in a fraudulent scheme from the get-go. This was not some investment that went wrong. This was a fraudulent scheme from the setup. The Court of Appeal didn't interfere with that. That would be my first preliminary point. The second would be Rule 20. I would say comes down to access to justice. That's why I was reassured hearing the questions being asked. We're all here for a just outcome, very abstract. I think it was pointed out by one of you justices. But when we bring it down one level, what does just outcome mean? Issues such as access to justice come in. I propose to you a slightly different than the approach that's been taken to date. I've heard many members of the bench talk about efficiency, cost of litigation. If they were standalone issues, I submit to you, we're in the justice business. They're crucial because a lot of times there'll be barriers to obtaining a just outcome. The government can worry about those factors as a standalone factors. To us, they're relevant because they become material barriers to gaining a just outcome. That is our focus today. I am going to spend very little time on taking you through what were the objectives of the revisions. I think the court is very clear on that. It was a more expeditious, but let's not forget, expeditious, efficient as it relates to justice. We're not in the efficiency business.
I wonder, though, if one of the factors that was on the mind of the Court of Appeal is really what was gained by submitting this case to summary judgment. As the Court of Appeal points out, it was a 3-year slog. You presented a bill of costs of $1.7 million, and there's going to be a trial against the other defendants anyway. So is this case really the poster boy for access to justice?
I would say, Justice Cromwell, yes. Let me give you some facts of that case. In 2010, Justice Grace ordered that there be a trial against Castles Park with dispatch. 3 years later, they brought extensive motions. Yet again, I think this was the third round, security for cost motions. There is a related third case, the Demessy case. It hasn't even come out of pleadings after 6 years. This is a unique case. There are over 60 endorsements, and this is a case-managed case. There's been the same master from the onset that managed this case. In our desperation, we approached the Associate Chief Justice in Ontario to ask for a judge to be assigned to this case, because we were stuck at times. We have a master who's case managing the case, but at certain points we have to go to a judge. Is it unique in that way? It is, but it would be the poster child for these rules. If it took $1.7 million to get this matter to a motion for summary judgment, you have to look at who created that record. Plaintiffs were examined across the board when they had nothing to say. In the Malding group, the only 2 key people who met with the relevant parties. So the practical aspect of this, to say that the plaintiffs were responsible or somehow they had a desire to prolong this increased cost, but it would be logical, Justice Cromwell, to say the defendants have nothing to gain from this matter getting to a hearing on its merit. Let's be very clear on that. On the second issue of why we're here, it is access to justice, and I would leave it at that. I would adopt a lot of the statements that were made earlier in this court, this abandoning this notion, romantic notion of a trial. I think that the phrase I use in my submissions is a motion for summary judgment isn't a poor man or woman's alternative to a trial. It is an alternative, period. At times it would be unjust, regardless of the party's resources or the court resources, to send a matter to a full trial. Those would be my comments as to the why we're here. There are 5 issues before you today that we need to deal with. The most important one is what we've discussed thus far. What are we to do with the new rules? How are we to approach them? Was the Court of Appeal correct? That's issue number 1. We've made inroads in dealing with that already. Second issue, we're proposing to you to take a contextual justice approach. Context is key. We've reviewed some of the decisions from DISCO. It's coming up everywhere. When we talk about efficiency, what is efficient depends on the context of the case. So a contextual justice approach is the second issue I'd like to talk to you about. Elements of the civil tort of fraud, and let's not lose sight of that. This is not a criminal proceeding. This is a civil case with accusation of fraud. And if you just look at the factual findings, I would submit you would agree with me it was a very reasonable allegation, to say the least. The fourth issue is the standard of proof in civil cases. I don't have much to say that, but I think it's worth mentioning to discourage lower courts from using loaded phrases, I would say, such as compelling. This court has dealt with cases where allegations are serious, sexual assault, fraud. My submission to you would be the one standard. It's perfect. We should discourage courts from using phrases, especially provincial appellate courts, where judges might be misdirected. We have to trust our judges on that issue. A judge sitting in bench in any Canadian province will have the foresight, the clarity of mind to give the care that a case requires. It goes without saying. We don't need to change the law on that. And on the issue of a prospective overruling, I have a few submissions on that, but I can boil them down as a non-starter. There was no prospective overruling here. And if there was, I can deal with that right off the bat. You can make the distinction between rules versus substantive law. Second issue, you can say the court has the right to do it, so I'm not going to spend a lot of time on that. Let me lay down some of the key facts. And the reason I'm doing that is to establish context. How can I ask you to follow on a theoretical level, a contextual justice approach, when you don't have some of these?
Could you explain exactly what you mean by context?
Context, Chief Justice, has to do, we use these abstract terms. I think one of the justices talked about, we use this word just for whatever we want it to mean. To give meanings to some of these abstract notions, we need to look at the specific facts of the case. Mm-hmm. Otherwise, they're meaningless. We just get up, say...
Are you suggesting that in approaching Rule 20, it should be based on a case-by-case evaluation of the factors as opposed to, for example, categories or general principles?
Absolutely, Chief Justice.
But isn't there a tension here, and I assume you're going to address it, because it's fine to say we should have a contextual approach based on the facts of a particular case. Each judge should look at the application, decide what will be fine. But whether it needs to go to trial or not. But surely there is a place for guidance to be given as to what kind of cases are appropriate, generally speaking, criteria, maybe factors, maybe categories. I'm not endorsing any of this, but what the Court of Appeal is trying to do is say these are the general guidelines which can help judges who are faced with this. So the suggestion is maybe there's a balance. Maybe you have to look at the individual facts of the case, but maybe there's a place as well for some generalization.
Absolutely there is. It depends, Chief Justice, where you start from. The problem, what happened with the Court of Appeal decision, they started with the class system. Then, to be fair to them, we have to keep in mind, they did state you have to look at each case on a case-by-case basis, but it was too late, Chief Justice. When you start from a proposition where you set out classes, then to end it by a footnote saying, but let's look at each case. My proposal to you to reverse that order, to state by saying the new rules are meant for cases to be dealt with on a case-by-case basis. Once everybody is clear on that, and the court might want to elaborate on why that is important, to say, now here are some guidelines. There's nothing wrong with those guidelines. But appellate courts have to be mindful that their statements are taken very seriously by everyone involved. And whether it's lower court judges, members of the bar, they're all looking for that bright line. You know, the Court of Appeal said this, now we have a class. That doesn't fit in there. Now, on the issue of the Court of Appeal decision, I'd like to highlight two difficulties I've had with it. I was involved in the case. They laid on this full appreciation test. We told the motion judge must have full appreciation of the case. But in other places, we're told the new rules, the new powers cannot be utilized unless the judge has full appreciation. Now, I'll demonstrate to you what my difficulty with that approach is. It's akin to telling somebody you need to know what's in a dark room. You need to fully appreciate what's in the dark room before you can turn out a flashlight. I just can't follow the logic. The new powers were put in place so that the motion judge could have full appreciation. To put them in as a barrier to full appreciation, I wish I could justify the logic. I cannot. That's one issue. The second issue is my friend cited the case of precious metals. That's an interesting case, actually. One of the defendants is a co-defendant, Mr. Peoples, in this case. And identical case to us. Huge volume of record. Court went the other direction. The only way we can justify that to defend the court's decision to say maybe they looked at the context. Then maybe they were following a contextual approach.
Well, maybe what you're saying is that you can have guidelines, but they're not strictures. They're not absolute rules. Is that what you're saying?
Justice Rockton, exactly. I think, but we need to.
So if that's true, then is there anything wrong generally, just very generally, with the Court of Appeals saying, well, where you've got multiple findings of fact, conflicting evidence, multiple witnesses, you might look at those things to see whether the case is amenable to summary judgment or not. Where it's documentary, few contentious issues and so on, maybe it's more likely, but don't treat those as absolute rules. Just treat those as indications one way or the other. But then, as you say, look at the context and see what you should do.
Absolutely. And as I said, I think the problem arose from we started with these categories. Then after that process was finished, the Court of Appeals said, oh, by the way, that case-by-case approach is important. And I think any direction coming from that court, I would encourage the court to start from the case-by-case proposition, to lay that understanding clearly out and say, now we have some guidelines for you. And the guideline you mentioned is something, that's absolutely, there's nothing wrong with that. But again, we go back to the issue of the new culture, the new regime. These rules were meant to give the motion judge, that's a judge hearing this. When you sit through a 4-day hearing of the nature we sat with this, you have extensive finding. In our particular case, there was an expert report from the world's leading authority on prime bank fraud. Justice Gray said, I don't need this. He rejected it. It was simple. It was clear on his face. He could have called viva voce evidence. He said, I don't need this. I've got affidavits from Mr. His explanations make no sense. He's claiming I used $450,000 of the Bruno money for corporate purposes. And let's remember, he has to put his best foot forward. What happened to the other $550,000? This is his own evidence. Is he telling us now that he would put in new evidence if we go to trial? What happened to the other $550,000, Mr. Henia? They went to cover the law firm's trust account? Do I need to make any? This is his own testimony. It's in the transcript. If Justice Grace came to the conclusion he did, he had ample grounds for it.
Does any of this turn on the expectations of the parties about the form in which the information comes to the judge? I mean, when you talk about 28 boxes and lots of affidavits, what's your view about whether or not that format is necessary in order to give a judge a sense, enough of a sense of what the case is about, that he or she can decide whether it needs a trial?
Justice Abella, my sense would be you err on the side of caution. You take the best foot best foot obligation, best foot forward obligation seriously. So you try to put as complete a record as you can before the motion judge. And as it was pointed out, you assist the motion judge to shift through this evidence. Out of the 28 boxes, most times the motion judge will come to say 4 documents, that's all I need. But if you don't have the 28 boxes, they're going to be left with the nagging dots. Did I have the full record in front of me? And that's what the new rules are meant to do.
That's exactly the point. Do they need the full record, or do they need enough of the record to be able to make an assessment? In other words, what does best foot forward mean? Does it mean everything your foot has ever touched, or does it mean essentially what the core of the case is about and let the judge ask questions based on what they've got in front of them?
In an ideal world, I would say the relevant, important material. In a practical way, the way litigation in Ontario at least unfolds, it'll come down to the council's litigation strategy. So I'm giving you what I perceive to be a very honest answer. Should it be just the relevant material for that motion? Absolutely. But does that happen in real life? I wish I could tell you yes, but I don't believe so. Going back to a few last couple of crucial factual points. Not losing sight of the fact there was no trading program, the fact money came in. Mr. Heniak in both cases issued directions about how it was to be spent, and he received the benefit in one of them, 100% one of them, it might be 50%, it might not. Now, as a matter of law, I would put you, there is no legal requirement that says a person who sets up a fraud benefit from the whole amount, especially in the factual details of this case. I'll use that point to deal with the elements of a civil case for fraud. The tort of deceit or fraudulent misrepresentation requires the following: false statement, knowledge of falsehood or reckless disregard, intent to deceive, reliance by the plaintiff. And this is a key point. The reason I'm taking through a list you already know, it's this key point, reliance. My submission to you is when you have reliance, inducement should be assumed, is submerged in there. If you don't have reliance, inducement is a factor. So that's my key point on that. I can point you to the relevant case law, but I think, you know, what I've said about it covers the area. Moving on to...
Could I just stop you there for a moment?
Yes.
This is not a convenient time. Just tell me and we'll come back to it.
Absolutely, Justice
The
Cromwell.
question concerns the elements of fraud.
Yes.
And there are 2 questions. First question, I think you acknowledge that one element of civil fraud, whether you call it deceit or fraudulent misrepresentation, is a false statement.
Yes.
Is there any place in Justice Grace's reasons where he recognizes that fact?
That I would assume you're referring to the Mauldin case?
In either case. When he said, as I read it, when Justice Grace sets out his description of what is fraud, he gives a quotation from a book on fraud and mistake.
I will get the reference.
Doesn't set out the elements of the cause of action.
I will get the reference for you, Justice Cromwell, but if memory serves me well, he does state there was no trading program to begin with. That's why our problem is a bit different. He makes that finding. There's no trading program to begin with. If there was a trading program, then we would have to get into the details. Was Mr. Bruno told this about this trading program? What were the Mauldins told? So the starting point is Mr. Heniak sets up a fraudulent scheme. He knows it to be a fraud from the get-go. So anything he does, the assumption, I think, for Justice Grace, Justice Cromwell, was that any statements or actions by Mr. Heniak after he sets up that fraudulent scheme is a false statement.
All right. And then that brings me to the next point. In the Bruno action, can you direct me to where the judge finds that Mr. Heniak made a false statement to Bruno?
I will look for that. My colleagues will, but two crucial points I want to flag. We are relying on the Armstrong decision on the issue of agency within a civil fraud case. And what that case stands for is very clear. Civil fraud can be committed through an agent, even if the agent is unaware of the fraudulent. And this is a key distinction, because at this stage, we don't know whether Mr. Peoples was a party to this fraud, he was just a dupe.
Assuming that you're correct, that the statement can be made either personally or by someone acting on your behalf, where did Justice Grace find that such a statement had been made in the Bruno action?
I will look for that by my initial response.
The Court of Appeal couldn't find it.
No, my initial response
I can't find it.
No, the initial response is the nature, the facts, the context of this case. You cannot be said to set up a fraudulent scheme, then there be a legal requirement that you make a statement to the effect. Oh, actually, I might be able to give you a few practical examples. Documents were signed. All the tropos, frontline, all the paperwork signed by Mr. Henyak purported to that this whole thing was a legitimate investment. There's extensive finding on that issue. Your point is a valid one. What I'm trying to get at, I think I can at least speak with confidence for the motion. Just for him, it was a no-brainer. He was there. He sets up the fraudulent scheme. He purports for it to be a legitimate one, and he actually signs documents to that effect. These were documents that were filed by himself. There's no doubt as to their validity or credibility.
I'm not sure that I'm following. Could I ask you just very quickly to look at paragraph 157 of the Court of Appeal, where they set out what they perceive to be the law of civil fraud? If you have that.
157, Justice Houghton?
Yeah.
Yes.
So, Briniac knowingly made a false statement to Fred Malden with the intent to deceive him. The false statement induced Malden Group to invest with Briniac, and as a result of investing with Briniac, the Malden Group suffered a loss. Now, I just want to understand, do you say that that is a correct statement or incorrect statement of the law? And if it's incorrect, what's wrong with it, and what authority do you have?
It's correct insofar as it's a general statement on the law. I think the one I gave is a more detailed one. For example, knowledge of falsehood, where you reckless. That's one point, finer point on it. Second point is the point raised by Justice Cromwell, that did the motions judge or the Court of Appeal ever put its mind to where was the actual misrepresentation? So, to answer your question, I would say it's a general correct statement subject to the qualifications I've put in, such as on reliance. When there is reliance, a big issue was made of inducement.
Well, but just a minute. Reliance, in order to rely, you need an inducement, don't you?
With all due respect, just starting, I would say once you have reliance, you can assume there was inducement. And I can refer you to authority, I believe is tab 90. Definition of reliance is the material we filed, and it does make a statement, and I'll get you the reference in that. I think it is tab 90 of our material, which basically, in short, it states once you have reliance, you can assume there was inducement.
But inducement by whom? I mean, isn't one of the issues in this case that maybe the inducement was by somebody other than Heriniak?
And that brings me to a crucial factual points in this case. Let's go back. Meeting is held in the Bruno, just to refresh the Justice's memory. A meeting is held in the offices of Castle Brock with Mr. Peoples, Mr. Cranston, Mr. Henyak isn't there. Okay? These are the crucial points in this case. Mr. Henyak gets a bill from the law firm for that very meeting. He pays it. Let's go further. Doesn't stop there. Mr. Peoples was his long-term lawyer who'd been involved in numerous similar meetings to pitch this investment. It gets even worse, Justice Rothstein.
But is the point that these people were acting as agents for Mr.
Absolutely.
Okay. So, seemed to be of the view at the time, or in their reasons, that they were looking for a statement by Mr. Heriniak, and they weren't exactly satisfied about the agency proposition and so forth.
Do I agree with the Court of Appeal? I don't, because it even gets worse. Let's follow the money.
No,
Who gets
sorry,
them?
But before you do that, I just want to make sure that I'm understanding the principle. You seem to be relying on the fact that if there is reliance, you don't, or inducement is implicit, but I'm still struggling with the connection because the inducement may come from somebody else. I guess that's where I'm having difficulty with your argument. It seems that the law is that there needs to be inducement, and I thought that the inducement had to be by the person who was intending to deceive.
I am looking for the reference for the material we filed where it exactly says what I've said, that reliance does encompass inducement. Again, I would take it a step further. Let's look at the context of this case. We can't have these debates in the abstract. And I think that's where we get into problems, where we engage in these debates without taking the particular facts of this case. And here we are at the pilot level trying to go back, the point I made earlier. The key is when the Court of Appeal, to highlight the problem I have with the Court of Appeal, we get two very different results in two sister cases that were heard by the same motion judge, same evidence was presented. Can I explain it to you? I cannot. On the elements of civil fraud, other than focusing on the agency and the reliance inducement issue, I don't believe I have anything more to say. I would like to use a few minutes to deal with this concept we put before you. What is contextual justice? What are the practical tips? Let's start with the proposition that was stated in the court earlier. Should there be guidelines? Absolutely. Should the court consider that, to set up a procedure, test, formula? Might be the case. If that's the approach the court deems appropriate, we submit there's an easy three-stage process that could be engaged. For the test, we're proposing to replace the full appreciation test. Number one, looking at the context. To look at the context of the case, the court must consider the evidence. This obligation to consider the evidence comes straight out of the rule. The new rule says the judge, motion judge, or master, if he's the master, shall consider the evidence. Second stage, establishing the connections. What is context? Another abstract term. But once you take it a level down, you look at the connections that make for that context. Looking at the connections that construct that context. And this is the point that the new enhanced powers come in. Should the motion judge use the new powers? We know the test. It says, they may use it unless it's in the interest of justice not to do so. My submission to you would be, once they take a careful review of the connections, then yes, those powers should be used, again, following the rule, unless it be in the interest of justice for those powers not to be used. The final stage in the test we're proposing to you is disposition and taking action. We've gone through the context stage, we've identified the connection, we've determined whether the new powers should be used or not. The court needs to engage. And that's the important cultural shift. The old mentality would have been to look for ways that nothing, it was a cultural mindset. We were looking for ways of not engaging. There's an issue here requiring trial, we step aside. I would say the mindset, the culture shift should be to one of engagement. We will engage, we will dispose of it unless it would not be in the interest of justice, for example, to use the powers, or there are certain matters that are appropriate for trial. There's no two ways about it. Keeping in mind what was said in this court earlier, A motion for summary judgment, it's not some cheap, some less desirable process than a trial. And that's going to be the biggest challenge for this court, to change the mindset of the judiciary and members of the bar that approach this as the same process we went through when we dealt with ADR going back 20, 30 years ago. There was a culture shift that people recognized ADR is valuable in the dispute resolution process. At this point, I'd like to deal with prospective overruling. As I stated at the beginning, there was no prospective overruling. Even if there was, just on the possibility this court sees some merit to that argument, I would make the distinction between rules and substantial law. And the third point I would raise is the point that this court has used the metaphor living tree for the Constitution. I would say the same metaphor would apply to the rules of civil procedure. More so, most practicing lawyers, we get a new rule book every year. That's how fast that tree grows. Courts constantly are faced with the situation they have to interpret them, develop them, and take them where they need to go. So those would be my questions on prospective overruling. I am going to take a few minutes to give you a few more facts of this case. I think they're relevant. For the simple fact, again, we have to go back to the context.
I'm sorry, if you're leaving, are you finished with prospective overruling?
Yes, I am, Justice.
Could I just ask you, you say there was none, and yet the Court of Appeal expressly says that in paragraph 152, we therefore conclude that going forward, cases such as the Malden Group action and the Bruno action require a trial. They should not be decided by summary judgment, and yet the Court of Appeal decides it by summary judgment. Isn't that essentially prospective overruling?
I would say
apply to everything in the future, but not to this case. And are they legislating when they do that?
I would say it depends how you interpret the Court of Appeal decision. We've had two arguments here. Are we to take the Court's decision on establishing guidelines, classes? Then maybe, yes, you're right. Maybe that's prospective ruling. But of the argument I've heard, no, the Court really put those as the guidelines and came to say it's a case-by-case basis. And if we take the latter approach, there is no prospective overruling. So when I state there is no prospective overruling, I'm going on the assumption that we've accepted the interpretation that the Court of Appeal decided at the end of the day matters had to be decided on a case-by-case basis, and its categories were merely guidelines. If this Court comes to the conclusion they were not guidelines, they were classes, yes, we have a problem.
Can I just ask you one question? I don't want to take you off your track. I keep coming back to the question of what is before a motions judge and what did the legislature intend when they enacted this to overrule Aguni and Ungerman. When I look at what is required on a motion, it talks about a factum consisting of a concise argument stating the facts and law relied on by the party. How does that get into 28 boxes?
Concise. Let me answer that, just Isabella, through using one of the more recent Court of Appeal decisions, the precious metal decision that we refer to. Same situation. Volume and volume of material. The point I'm trying to get at, just because the volume of the record is large doesn't mean the issues haven't been narrowed, haven't been put before the court in the most efficient manner possible. I see your concern, but
It wasn't a criticism, sir. It was more a question of whether part of the problem in dealing with summary judgments and the fact that they have become so out of control and in some ways not the alternative to trials. I'm just wondering whether one of the things we shouldn't be looking at is what was meant to be happening on a summary judgment motion. You've got a request from the legislature that the parties provide you come to the Supreme Court of Canada and you've got a factum of 40 pages and the arguments are made. So I'm just wondering whether one of the things we shouldn't be thinking about is the extent to which the parties feel obliged to provide every shred of information rather than following what was intended, namely give us the case, tell us a summary of what the facts and the evidence are, and we'll decide whether on this factum we can either decide the case or it can go on to trial. We just seem to have moved, as you say, this has been many, many years, much money, and I'm just not sure that that's in character of the spirit that was intended here.
I think I appreciate your question better now, Justice Isabella. I have to distinguish between the material that's filed with the court in Ontario. We're subject to our own limitations. Nobody ends up filing endless amount of material. But on a motion for summary judgment at times, such as our case, extensive material relating to the evidence is put before the court. And I don't seem to be having much problem with that because we are telling a potential defendant, the respondent in the case, you will not get a trial. If we are going, we've taken the approach that, you know what, we shouldn't be so big on trial, but on the same hand, they have their role, there has to be a balance, there has to be some security for the respondent in that. You have to lead by Trump. And I'm using phrases coming out of our existing case law. In those cases, you need to err on the side of caution and file the most complete record you can. But it goes back to what the new rule says, that counsel shall assist the motion judge in shifting through this.
Can I ask you this, because it's not too long ago that I remember having those boxes and boxes on summary judgment motions. Could the volume and nature of the record be dealt with on a motion for directions under Rule 1.05, and would it make particular sense that that be the judge who seized of the summary judgment motion? Is that one way of dealing with this issue? That's music, Justice Karakandis, to my ears. And if this court could mandate those changes, we've got the AG's office, hopefully they're taking notes. Those are practical approaches, and they're needed whether they come through new regulation, legislation. They make absolute sense. Another point that was mentioned in this court, having the motion judge be involved in somehow, whether he or she seizes herself or being involved with the process afterwards. Well, let me just make another suggestion. I'm just trying to look at the rules and see if there is a mechanism in the rules to make, to improve the access to justice concerns. In addition to the motion for directions, when you're looking at the reasonableness of the action for the purposes of costs, would the failure to bring a motion for directions to help deal with a voluminous record be an appropriate consideration in determining costs, reasonable behavior, and therefore costs?
Absolutely. What I understand from your comments, there's certain powers that are already in the rules. We need to utilize them more, sort of direct our minds to them. There might be new provisions that need to be added. But what I'm hearing from the court is a practical approach And again, it goes back to a just outcome argument. I'm not standing here and again stating we're in the efficiency business. That's the approach I would fully endorse. And if this court could issue any guidelines to that regard, we would be very supportive of it. What I would like to do is give you my concluding remarks. A lot of what I had to say on Rule 20, it's been covered, and I don't feel the need to go over it because the mindset I see from the court is one which the plaintiffs in this case very much endorsed. On those general issues, I would just highlight two things: practicality and the just outcome. Beyond that, I don't think I could add anything. If I have any remaining time, if the court will indulge me to use my reply, I would appreciate that. I'm only going to need a few minutes to make my concluding remarks. In closing remarks, I ask that the court keep in mind the following key points. The Court of Appeal's formulation of the full appreciation test under Rule 20 is contrary to the purpose and policy behind the amendments to Rule 20, which was to increase access to justice and to provide the motion judge with increased powers to resolve cases and determine when there is no issue requiring a trial. You summarize that: access to justice, new powers, new culture. The Court of Appeal further incorrectly stated the elements and standard of proof for the tort of civil fraud in the Bruno case and ignored the motion judge's finding of clear, cogent evidence of Herniak's fraud. That's a question the court has to ask. Did the motion judge make findings that were clear and cogent? There is no genuine issue requiring a trial with respect to Mr. Herniak's liability in the Bruno matter and to force these plaintiffs to not proceed to trial when there is clear and cogent evidence establishing Herniak's fraud would run contrary to the purpose and policy behind the amendments to Rule 20. Last but not least, I will conclude by going back to the 2 points I started with, the who and why question. Who brought us here? Who is Mr. Herniak? Let's use a different finding, this time from the Court of Appeal. And this is what the Court of Appeal had to say about Mr. Herniak. Having reviewed the extensive evidentiary record, we conclude that it firmly supports the motion judge's determination that Mr. Herniak committed the tort of civil fraud against the Malden Group. Herniak's defense to this action simply has no credibility. We can't lose sight of these facts. We can't make law in the abstract. This is all about context. With the above finding in mind, and considering Justice Grace's lengthy decision and his findings about the fraud committed by Mr. Herniak, I confidently put to this court that should this court overturn the Malden decision on some narrow technicality, such as prospective overruling, or not grant us relief in the Bruno decision, it will not only be a dark day for the administration of justice, but a result that will shock the average Canadian citizen due to the simple fact that Mr. Herniak will go down in Canadian history as the only fraudster who not only was able to use the legal system to commit his fraud. Let's remember, he used the good name of a leading Bay Street law firm, door boardrooms, the facts of this case. He used the legal system to commit his fraud, but was also able to utilize the system of justice to walk away from the civil consequences. Not only such results would be unacceptable in the context of this case, it would bring disrepute to the administration of justice in Canada. I can assure this court those are not hollow statements by me. My level of concern in this case is so high, I've made this statement and I'll make it in open court. I've undertaken to my clients, if I feel they did not obtain justice, I will hang my own rope. It might be a good thing considering the experience you've had with me, I'll put that to you, but I'm sure this court, like every court, has counsel standing before it, hearing these abstract notions, strong statements, the real people here who've been through a lot for the past 10 years. And that's what I would encourage the court to keep an eye on. Those are my submissions, subject to any questions.
Thank you very much. The court will rise for its morning recess.
On this matter is that the Court of Appeal unnecessarily and contrary to the wording of the new Rule 20 has restricted the use of it and thereby impeded access to justice, which was the very purpose of the rule. And I'll be making 3 points. First, what the aim of the Osborne report is, the impact of the Court of Appeal's decision on Rule 20, and our submissions as to the way forward. And if I'm going over areas that you are familiar with, please feel free to stop me. The Osborne report was commissioned and subsequently implemented for the primary purpose of making the civil justice system more accessible. And there were a number of amendments proposed which were then implemented. And just to give you a context, some of the amendments that were proposed and implemented were the proportionality rule was introduced, the simplified procedure, the limit was increased to 100,000, discovery times curtailed to 7 hours, and then Rule 20 amended. And unlike what the Court of Appeal says, there wasn't one rule that was more important than others. All of the rules were important, because the problem at that time with the civil justice system was viewed as it was too expensive, took too long, and was too complex for the ordinary litigant. Hence, Mr. Osborne's recommendations. Now, looking specifically at the Rule 20 amendments, as this Court well knows, the previous jurisprudence was that on a motion for summary judgment, a court could never assess credibility, weigh the evidence, or find the facts. Rule 20 specifically amends that jurisprudence. And our submission is that the problem with the historical approach to summary judgment was the notion that expedition, expense, and efficiency had to be balanced against the need for a fair process. And the new Rule 20, as drafted, by providing the motions judge with exactly those powers that he or she did not have, seeks to correct this balance. And the access to justice, the public policy purpose of the Osborne recommendations, in fact, brings together expediency, economy, and efficiency, and sees it as part of a fair process. And my submission is, when looking at the new codification, one should look at 2004, 2005, and 2006 as a package. Now, the Court of Appeal acknowledges the intent, but then in my submission goes on to rhetorically and substantively constrain the availability of this rule. And the cumulative effect of the Court of Appeal decision is to clearly state a preference for a full trial, the conventional trial process. And the Court of Appeal cautions that being knowledgeable about the content of a motion record is not the same as fully appreciating the evidence. This, although under the new rule, a motions judge can call viva voce evidence. But the Court of Appeal, in fact, constrains the ability of a motions judge to call viva voce evidence when it states that it would be better to engage in this process only after discoveries. And then the Court of Appeal proceeds to create categories, and if there are guidelines, that's one thing, but if there are hard and fast categories, that serves as a disincentive for the use of this summary judgment procedure. And the Court of Appeal proceeds to caution against using the powers of 2005. And it proceeds to introduce a new process, that of a new motion, a motion to stay or dismiss the summary judgment motion. So we have motions on top of motions. The problem for the Attorney General is that the culture shift that the Attorney General had intended to bring about by the introduction of the new Rule 2004, which codifies, it's a codification of the process for summary disposition, has been strongly discouraged by this decision. The aim of the justice system is to resolve disputes fairly and justly. A conventional tool is the trial, but there are many others that are found in the civil justice system, such as settlement conferences, pre-trial discoveries, case conferences, and cost provisions. And in fact, when you look at the entirety of the civil justice system, you will see that all the incentives are built in to, in fact, use the trial as the last resort. Obvious example is the Rule 49 cost provisions, right? You better be very sure before embarking on a full-fledged trial. So the Court of Appeal, by tilting in favor of a full trial process, actually is not in step with the philosophy of the civil justice process. Okay, so the question then becomes, where to now? So I think it's important to look at what has changed under the new Rule 2004 as opposed to what existed before. In both rules, you have to find a genuine issue. But under the old rule, once you found a genuine issue, for the most part, the analysis stopped there and you were off to a trial. But here, the rule uses the words requiring a trial, and I'm not so sure that requiring a trial in and of itself is so determinative. Then it sets out the new powers of a motions judge on a summary judgment motion, weighing evidence, assessing credibility, and so on and so forth, and provides the ability of a motions judge to call viva voce evidence if he or she needs it, feels that he or she needs it. And then it provides under 2005 for the disposition of the matter in the event that motions judge using the powers of 2004 cannot finally resolve it. And in 2006, the onerous cost consequences that used to exist for a failed summary judgment motion has been removed. In my submission, this makes it extremely clear what the intention of the rule amendments were. Now, the issue is, the second issue is, what does the interest of justice mean? And my submission is, looking at the scheme as a whole, it simply cannot mean full appreciation as stated by the Court of Appeal. That is, that a motion judge decides before using the tools available under Rule 2004 whether she can have total familiarity with the evidence. This, in my submission, is limiting interests of justice to a very narrow category. My submission is the interest of justice should take into account other factors such as proportionality, affordability, efficiency, all of these factors which play a part in attaining justice.
It seems to me that the bottom line is you're proposing a highly discretionary approach to this rule.
Justice Cromwell, I would say that we are proposing a discretionary approach, and I was
certainly your test, as set out in paragraph 26 of your brief, is very open textured, if I can use that word. I guess the concern is, though, that where there's discretion, there's uncertainty, and where there's uncertainty, there's cost.
Yes.
That the Court of Appeal was trying to put more certainty into this so that you didn't end up on a road to nowhere.
I think that, my response to that would be the Court of Appeal, in attempting to do that, any rule has jurisprudence that comes about that ripens the rule, but by its tilt towards a preference for a full trial has in fact completely taken away what the rule was intended to do. Guidelines, all rules have jurisprudence that then give body to the rules. Guidelines, we have no issue with. But my submission, there is guidance already that comes from British Columbia. Now, I know the argument is in British Columbia it's a summary trial rule as opposed to a summary judgment rule. My response to that is that in Ontario, there was no need to go to a full summary trial rule because the summary judgment rule 2004, 2005, and 2006 provided all the tools to a judge, a motions judge, who wanted to then to be able to dispose of those matters which they could. Thank you.
Good morning, Justices. You should have the condensed book of the Intervenor Canadian Bar Association. Justices, the full appreciation test is, can the full appreciation of the evidence and issues that is required to make dispositive findings be achieved by way of summary judgment, or can this full appreciation only be achieved by way of a trial? We support the conclusion that any judge needs a full appreciation of the evidence and issues to reach a just result, but in our submission, the Court of Appeal applied the test too rigidly. The test is set as a binary question. Do I or do I not have a full appreciation? If not, then on to trial. In our submission, the Court should be using the interpretive principles in Rule 1.04, that the rules shall be liberally construed to secure the just, most expeditious, and least expensive determination of every civil proceeding on its merits, and also the amendment that was included in this parcel of amendments to deal with proportionality, and that is that in applying these rules, the Court shall make orders and give directions that are proportionate to the importance and complexity of the issues and the amount involved in the proceedings. The Court needs to use the flexibility to use it as an effective building block in a proportional and efficient dispute resolution process. And in practice, what that has to include is, first of all, flexibility in dealing with oral evidence. The Court has power to hear viva voce evidence, and the Court should consider hearing that viva voce evidence if they need to get a full appreciation and to use the summary judgment so that it's proportional and efficient. And secondly, let's deal with complexity. The issue of complexity is not determinative. Motion judges have an uncanny ability to actually see the forest for the trees in motions and to understand that where there's smoke, there may not necessarily be fire. But the complexity comes clear when you look at where there's a modest amount in issue. If there's a modest amount in issue, a 6 or 8 week trial for $200,000 just doesn't seem to be proportional. But you need to craft the appropriate resolution dispute determination process so that you can get the correct answer. And as we know, even after a full trial, you're not necessarily entitled to perfect justice, but you ought to be able to apply the principles and get the just result. The third thing that one needs to consider is the ability to use the provisions of Rule 20.05 to then craft the appropriate orders, because if the Court can't, despite the paper record and despite the aid of viva voce evidence, if the motion has to be dismissed or the motion is only granted in part, then the claim must continue. And what the Court needs to do at that point is to salvage what has been used and create an appropriate dispute resolution process. Unfortunately, The Court of Appeal in combined error appeared to limit the ability to use that Rule 20.05. In particular, I'd refer you to paragraph 65, which is found at tab 5, but at the end of that paragraph, the Court of Appeal says, any trial management order flowing from a failed summary judgment motion must facilitate the conduct of a genuine trial that will permit the full appreciation of the evidence and issues required to make dispositive findings.
Can I ask you, if we were to use that rule as a way of actually fashioning an appropriate process that's proportionate to the nature of the issues involved, would that interfere then with the way a trial judge could conduct the trial? And I guess my question to you, is there any reason why the judge who's fashioned that appropriate process and put the limitations in place can't also be the trial judge?
First of all, it does have an impact on the trial, and it does fetter the discretion of the trial judge, and that may be an issue that needs to be addressed, that it's appropriate to do that because we're looking at the principles of proportionality and we're looking at efficiency in the system. But with respect to the issue of the motion judge remaining seized, Justice Brown, in the OPTEC decision, which is found at tab 6 of our condensed book of authorities, he specifically addressed that issue and thought to himself, in this case, I would like to remain seized of this because I have the familiarity with it. There may be a problem scheduling, but I think it's appropriate that I remain seized given all the information that I have. So I think that it poses a solution that I think ought to be considered. It's important to have that ability.
Would it be your thought that that would be an appropriate approach where a summary judgment judge has found one of the parties to be a liar?
You're saying in the context of granting a partial summary judgment?
In the context of staying on board as the trial judge while other claims against that person are tried.
Well, I suppose the concept, I think, would be, if you're talking about a partial summary judgment, it's more complicated. But in the normal course, Rule 20.05 would be applied when the judge has said, I am unable to get a full appreciation by what I have before me, and I haven't made any dispositive findings yet. So I don't think the judge would have tipped his or her hand at that point, but the judge will say, I want to fashion this into a dispute resolution process.
Let's take a hypothetical case with facts similar to the Bruno file.
Yes.
The summary judgment motion is dismissed, but the summary judgment motions judge made very strong findings of credibility against one of the parties, who will be a party to the upcoming trial. I guess I'm just wondering what limits there are on the ability of the summary judgment judge to stay on board.
I think there may be limits, and that's a consideration, I suppose, the appearance of justice and how that plays into the issues that we have about efficiency and proportionality.
So I thought you were addressing a situation where the judge gets into it and says, I can't do this summarily. And so the judge has not made those kind of findings. And then you're talking about the problem of how, if at all, that can segue into a real trial. And you say in that circumstance maybe it could be before the same judge?
Yes, that was.
But that would always depend. If the judge made a lot of findings, it seems pretty clear that he wouldn't be the appropriate person.
But unlikely, I would think that the judge wouldn't make a lot of findings if the judge is determined, I cannot make that decision, that he or she would say, but what I can do is, having looked at all this material, say, we really need to hear from these 4 witnesses and we really need to have 2 experts talk, and we can do this all in 3 days, and give me your opening statements right now or in a timely fashion, and we can get this thing done. And then I will believe that I have the full appreciation to make the dispositive findings necessary. So yes, Chief Justice, I didn't want that example, but that was the one that was given. And the other important thing is that the 2005 procedure isn't necessarily the genuine trial. It can be the appropriate dispute resolution process, and the Court of Appeals' focus on it being a genuine trial, I think, is misplaced. it doesn't take advantage of the ability to secure the just, most expeditious, and least expensive determination of the civil proceedings on the merits, and it doesn't give full credit to the amendments to the rules. And one other submission that I would make is that the judges need not be passive spectators in the courtroom. They're entitled to assert control at all stages of the litigation to ensure proportionality and to satisfy the overriding need for justice to be dispensed in a timely and cost-effective manner. Those are my submissions, if you have any questions.
May it please the Court, let me start by saying much of what we would have presented has already been presented by institutions of like mind on the subject, and I should say that the Advocate Society aligns itself with the submissions of the Ontario Bar Association and the CBA. We'd like to emphasize that this access issue under Rule 20 is about access for ordinary Canadians where high costs associated with litigation, in particular the trial process, has denied ordinary people the opportunity to have adjudication. This is not true necessarily of institutional litigants, and some institutional litigants thrive on these complex cases and complex trials. But our submission is the focus should be on ordinary citizens, number one, and number two, who are seeking adjudication. There is a tendency to say, well, there's always mediation, but mediation, as I'll come to in a moment, has another purpose and should not be relied upon to compensate for an inability to secure adjudication for those who cannot afford the high cost of trial. Obviously, the Rule 20 solution, as has been pointed out by others, is a culture shift, and it's a serious accommodation for all of us, the judiciary and the bar, to make this shift. It's very different. Certainly, those of us at the bar love the system the way it is, with elaborate trials and reports to our partners as how well we did in the third or fourth or fifth week. But the fact is, there is a very, very compelling need to fix this. And Justice Osborne's solution was, as everybody has said before me, to turn the process on its head and allow the motions judge to deal with things that theretofore had been prevented. I say with the greatest of respect, the Court of Appeal did not take up the invitation to shift the culture, because what they have said about trials makes it clear that trials, except in extraordinary circumstances, are the inescapable conclusion of the litigation process. And that, with the greatest of respect, I submit, is inconsistent with the cultural shift. Effectively, the Court of Appeal, as has again been pointed out by others, has undermined the objective of these amendments by, first of all, extolling the virtues of a trial and then identifying this abstract, generic category of cases said not to be suitable for summary judgment. And if I might just at this moment address a question you asked, Justice Rothschild, about whether guidelines, general guidelines, might be a helpful alternative. And I would say with respect, I would discourage that, because I believe the rule should operate in accordance with its terms, and to discourage or encourage its use, the cost penalty is practical. If you have guidelines or preconditions, the fact of the matter is that it's likely they will then become a basis for either electing not to grant summary judgment, or more important, as I'll come to in a moment, discouraging litigants from applying for summary judgment. And the presiding judge, if the presiding judge is looking at 20 boxes of documents to review, and there's a guideline that appears to inhibit hearing the motion, I would submit there's a risk that guidelines could become preconditions, and in my submission they are not really necessary.
So do we just say it's total discretion and just...
I would say it's a process of developing jurisprudence on a case-by-case basis, and it may be, Justice Rothstein, that down the road, the jurisprudence has become a de facto guideline. But if you establish a guideline out of the gate, the implication is that it is a policy reason for not entertaining summary judgment applications. And all I'm saying is I would discourage that as an alternative. The principal step which the Court of Appeal took to undermine summary judgment was, or undermine the amendments, was to discourage oral evidence. And oral evidence is absolutely critical to these changes. The Court of Appeal has said the cases should be based on a paper record and have in effect discouraged the use of oral evidence. And without oral evidence, this rule doesn't work, because the rule will result, properly applied, in oral evidence in respect of some aspects of the case and not in respect of others. None of the conditions that have been proposed, preconditions, are found in the rule. They've been grafted upon it and imposed by the Court, and they ignore, as I've already said, the cultural shift imperative. One of the negative impacts of these preconditions is that they will discourage resort to summary judgment and thereby deny the litigant the salutary effect of Rule 2.05, which is the added process. And that is a serious difficulty, because there is no other basis for finding in the rules the procedures contemplated by 20.05, and so the preconditions, if they discourage litigants from applying for summary judgment, 20.05 will be lost. By reason of the Court of Appeal dictates, Rule 20 will be undermined, and ordinary Canadians, being unable to afford the cost of a trial, will have no alternative but to accept mediation out of the system. And if a trial is ordered with a litigant that cannot afford the cost of it, that is the net result, because it's not as though by ordering a trial the shortcomings of the system are overcome. They're in fact magnified, and that is what happens. There is a mediation, and the person who is seeking adjudication is denied it by reason of an expensive trial in the offing. Or worse, the ordinary citizen may elect, as many are doing, to represent themselves. So if a trial is ordered in a particular case on the basis that the rules should not apply, either the litigant will be denied adjudication by being mediated out of the system, or undertake to represent themselves, which creates even more serious problems. I would conclude by simply saying this: I would be wary of some litigants who are supporters of the status quo, because some litigants, some plaintiffs and sometimes defendants, utilizing the status quo, the complexity of the process, can drive the course of the litigation to the point where there is a mediated solution in their favor. So some litigants like the process because it takes them to the point where their opponent is basically exhausted by the process and succumbs to mediation. So in assessing what the proper approach is, remember, I would submit with respect that there are some who favor the process as it exists and would resist reform. Those are my submissions.
On behalf of the 1,400 members of the Ontario Trial Lawyers Association, I would like to thank the Court for allowing us to participate in these important appeals. You will have seen from our factum that we take a more cautious approach to summary judgment than our colleagues. No doubt we all share the same objective, to make our civil justice system the best that it can be, but have different perspectives on how to achieve it. As trial lawyers, familiar with the difficulties that trial judges wrestle with, even after hearing oral testimony, in deciding who to believe and sifting through complex facts, we recognize the need to be vigilant before allowing motions judges to embark on that process. 2 points are certain. First, everyone agrees there are some cases that require a trial for their resolution. The intent of the Court of Appeal was to separate the one from the other. Second, no one benefits from a failed motion for summary judgment, least of all the justice system. Even the winning party will be substantially out of pocket. The Court of Appeal recognized the need to provide guidance to judges and the profession in the form of categories of claims or features of a legal claim that lend themselves to summary determination. The Court gave further direction in the form of the full appreciation test as to what threshold should be met before a judge is satisfied to proceed with the motion and grant judgment. Our colleagues are critical of the decision, but with respect, there's nothing in their facta that would provide guidance to litigants on when a motion for summary judgment should be brought. The factum of the Attorney General amounts to an exhortation to judges to make use of their expanded powers. But that's only going to be helpful if the powers can properly be used to grant the motion. Otherwise, the hoped-for benefits from the process won't be achieved. There's nothing in the Court of Appeal decision that says the expanded powers shouldn't be exercised. The purpose of the Court was to say when they can most usefully be exercised. At paragraphs 47 to 49, the Court makes a more fundamental point by contrasting the process of decision-making between a trial and a motion for summary judgment in complex cases. The unfolding of evidence in the presence of the trial judge, the Court says, offers a greater assurance of accuracy than a fulsome review that would occur in chambers. In our view, that point is unassailable and fundamental to our conception of what justice is about: the search for truth, a fair process, and correct outcomes in individual cases. Our colleagues make the case for expanded summary judgment in savings of cost and time. In our submission, summary judgment must be looked at within the broader context of the contemporary civil litigation system. The vast majority of cases, over 95%, will settle before trial. There's mandatory mediation and pretrial settlement conferences with a judge. Case management is available if asked for. In Toronto, a specialized commercial list features judicial involvement in getting cases to trial on an expedited basis. For cases of 10 days or less, trial dates are readily available in Toronto. The argument that we need an expanded summary judgment process to deal with cases faster and cheaper must be assessed in light of all of this. Long summary judgment motions aren't fast and they aren't cheap. They don't offer a greater assurance of a correct outcome, and a successful motion might be overturned on appeal, putting the parties right back to square one.
What's a correct outcome?
A correct outcome is one that is correct based on the facts that are put before the court.
In accordance with a particular judge's opinion.
That's right.
And why do you have an assumption that you can't do that on a summary judgment?
Well, you can do that in a summary judgment. It's a matter of when is it most appropriate to do it in a summary judgment. What the Court of Appeal,
I guess it's just a question of whether you start with the proposition that what you're looking for is a correct judgment, or you start with the proposition that what you're looking for is a process that will resolve a dispute where possible between the parties?
Absolutely, where possible, and that's exactly what the Court of Appeal, I think, is getting at, because their view of the matter, I would suggest, is that if you start down the road of bringing motions for summary judgment in cases that are not going to get the result of leading to a final conclusion, then you're just overlaying the process with another costly exercise instead of going down the normal course. And one of the points that we make in our factum is that when you look at the rules for discovery versus the rules for motions, what you find is that under the rules for discovery, we now have time limits of 7 hours per party, and you're not allowed to examine non-parties or witnesses or experts. But when you've got a motion, or a motion for summary judgment specifically, it's open season. You can examine till the cows come home. And so the point that I would suggest is that summary judgment is not an efficient process in any of it.
Well, we're stuck with it. The legislature did it.
Well, they did it in appropriate cases, Chief Justice. They said it was all anchored in the interest of justice. The powers can be exercised where it's in the interest of justice to do so. And my question is, did justice change from 2009 to 2010? I think not. What they did was to give more tools to the judge to make a decision where it's appropriate to do so. And I think if you look at Justice Osborne's report in the first place, you'll see the context of these appeals is summary judgment in complex cases. Let's not lose sight of that. And it seems to me that even Justice Osborne was not anticipating that these powers would be exercised in complex cases. And he refers, for example, to the summary trial procedure and quotes that it's useful in the hands of litigators wishing to have a civil dispute of modest dimensions adjudicated in a speedy manner. So even in British Columbia, where they have the summary trial rules, which is broader than our summary judgment, it's not used in complex cases. And I think that's what the Court of Appeal is getting at. Don't use it, or use it only when it's useful to do so, when there's some assurance that you'll get a final outcome.
When you, in your factum, you relied on Hercules Management and Gordon Capital.
Yes.
Which were tests that said, look to see whether or not there's a real chance of success. Where do you factor that into what you're submitting today?
Well, the actual test hasn't changed. And even Justice Osborne says that the test itself hasn't changed. It's still, is there any hope or chance of success? And Justice Osborne doesn't say anywhere that that was intended to be changed. All that was intended to be changed was the power of the motion judge to resolve disputed issues of fact. We fully accept the proposition that a motions judge has the power to resolve disputed issues of fact. In resolving those disputed issues of fact, the judge is to apply the same legal standard as has always been the case. Is there any hope or chance of success? And so, and one of the points that it comes out of Gordon Capital is that you can't just make bald allegations without supporting evidence. And that's not going to get you over the hump of creating a genuine issue for trial. That wasn't the case before, and it's certainly not the case now.
Are you comfortable with the way the Court of Appeal has set out the relationship between the chance of success and the full appreciation test?
It seems to me that the full appreciation test is an adjunct to the categories of claims. It's there as a further buffer, if you will, or you might call it a gut check for a judge to apply before they decide whether they can safely proceed and go down the road of deciding the motion. So I would conceive it in that manner.
Mr. Heydary?
Sitting there in my chair listening to the arguments, implying, accusing different parties of not, making the culture shift, I realize I'm as guilty as anybody else. To begin with, I'd like to refer you back to the rule 2.1, the new powers. When we read that, clearly it states the motion judge, subject to the test being in the interest of justice, has a lot of powers, including drawing reasonable inferences. That's our new rule. I'm counsel for the plaintiffs. I didn't even raise it. I was asked by Justice Johnston, Justice Cromwell. They're having problems with Bruno, and they're asking me to address those problems. But my answer should have been the new rule provides the platform, the basis for a motions judge to make inferences. So that's the law, that's the context. Now we switch over to address the two issues that were raised, the inducement issue, reliance issue, the Bruno issue. Justice Grace gives us an extensive decision, explicitly says, I have the powers to make these inferences. As appellate court, it's open to you to decide whether they were reasonable inferences or not. And he goes on to make extensive findings on these issues. Was there inducement? Was there reliance? Where did the money go? And related to that is, Justice Abella, your point, the difficulty you flagged with the volume of record and how does this tie in, I would tie those two issues together. It's an issue of the sufficiency of the record. The question appellate court should ask, was the record sufficient? It's not a size issue. It's not a volume issue. In a certain case, 2 volumes of material might be sufficient. On the flip side of that, was the inference reasonable? Now, I can take you through numerous passages where Justice Grace takes us a step by step through his thinking. Why am I making that inference? Why am I making that finding? The most crucial one goes to the fact there was no legitimate trading program, but Mr. Henyak presented it as such. This is a crucial. When you set out a fraudulent scheme, and you present it to the world, there's your misrepresentation, and once people sign inducement. It's very different from a contractual situation. I would distinguish it from Parna. My friend cited the case Parna. It's an excellent contrast. To refresh the court's memory, that related to purchase of an apartment building where a sophisticated apartment operator, I think that's the phrase used, bought a new building. They knew everything about that building. The contract contained a schedule with the expenses. They knew to be inaccurate. They turned around and sued the person who sold the apartment building for fraud. And that's a great contract to show you it doesn't apply in the context of this case. The motion judge had reasonable grounds to make the inferences that he did, and the new rules provide for that. Moving on to my next point. I was asked for the authority on the issue of inducement and reliance. I would refer you to tab 90 of my friend's book of authorities. On page 1171, there is an article, and I am going to refer you to the last sentence of the marked passage. In the law of misrepresentation, inducement denotes the required impact on the mind of the representee, also referred to as a reliance. Between those submissions, I would encourage you, I don't want to take the court's time. I'll be taking you through the passages in the Justice Grace's decision, but it's crucial you read those. I can give you the citations, paragraphs 168 to 170, reasonable one. My friend, Ms. Batner, made the statement, and the Court of Appeal seems to be saying, complex cases are not suitable for motions for general judgment. I would adopt Justice Abalo's point on that. Nowadays, I'd like to see a simple case. The cases, the way they're litigated these days by nature, are either complex or made to be complex. So that is a practical point to take into account. Now, also the point was raised, what happens when we have a failed motion for summary judgment? Justice Karkanis raised the point, there are many tools in the process to manage what comes after, and I'd like to give you a good example of our own case. The motion judge made issued a number of orders. Examinations were to be used, transcripts. We gained a lot out of that. If this matter goes to trial against other co-defendants, much is gained. It was established this was a fraud. We're not going to spend 6 months in trial arguing the case is brought. Was this a legitimate program? Or was it? Becomes an issue, really a strict legal issue. What was the level of viability? So much is gained, even in cases such as this. But I would adopt the proposition that there has to be more involvement by the motion judge. How do we achieve that? I don't have a solution for the court. Also, the statement was that fraud is a quasi-criminal matter. I disagree. That's incorrect. This is a civil fraud. This is a civil case involving a claim of fraud. There's no quasi-criminal proceedings here. So I think that's an important point to keep in mind. In closing, what I would like to do is highlight the fact I think one of the interveners has stated there is a compelling need to fix this situation. I think that's an accurate statement. That being the case, the only assistance I can offer the court is to adopt Justice Abalo's words and say we need a new map. And this new map has to chart the new culture for us, all of us. Even myself, my opening line was, I should have recited the new rule to you. I should have said the judge Justice Grace had the right to make reasonable inferences. But I didn't, because culturally maybe I haven't made the change. It won't be easy, but I'm confident the court can provide us with assistance in that regard. Those are my submissions, subject to any questions the court might have for me. Thank you.
Thank you very much. We thank all counsel. The court will reserve its decision on these cases, and the court stands adjourned.